Good evening and welcome to Be Informed. My name is Carl Buhariwala and I founded Be Informed to help people make good decisions. Today we're looking at the topic of employee rights and we're joined by Paul Cott of Law and Lydiard, who will be talking to us today about underpayments to employees in Australia. So the information in this seminar is current as of this month and is reflective of the Australian jurisdiction. So if you are joining in from overseas, please, you might want to reconsider its applicability because the information in today's session is general only and is in relation to the Australian principles. And also, if you wish to look at this seminar in the future, you may wish to also check whether it's still current as well. From a housekeeping perspective, the seminar will take around about 25 minutes, followed by a Q&A. And Paul Cott has kindly prepared a one-page handout, which I'll share with registered participants by email. Today's session is being recorded, so if you do have to leave early, or if you have joined late into the piece, this entire session will be available on our YouTube channel following the closure of today's session. So with that in mind, Paul, I'll hand over to you and we'll get into the seminar.
Yeah, thanks, Carl. And as I spoke to Carl a minute ago, I mentioned that my camera's not working. So normally we do record these with the camera working, but in this case, we're not. But hopefully the listeners and viewers will get as good an experience of educational and informative about underpayments to employees in Australia, which does cover non-payments, so not just underpayments, which is payments that are less than what's due. We also cover non-payments, and these principles cover and relate to non-payments of entitlements to employees, and also late payments as well. We'll cover that in particular, whether there's a right to interest for the employees who might get paid late. A relatively uncommon thing, but we do hear about it every now and then, and it's a common inquiry as to whether the employee is entitled to interest when they're being paid late. So now we just go to the next slide, if we can, Carl. Yep. So as it says there, we are talking mostly about wages, but there's a whole host of other entitlements. And researching for today's seminar, come across that there's a lot of things that we're talking about, such as wages. We're also talking about superannuation, which is governed by the Australian Taxation Office. That's their area to follow up. Annual leave, sick leave and carers leave, redundancy pay, and a whole host of allowances such as clothing, meals, travel, first aid, uniform, all those things. So underpayments can apply, or non-payments can relate to all those things, and maybe even one or two more. The payments must be made by the due date, or penalties can apply. That's correct, and it is actually quite a tight time frame in relation to payment of wages. It's commonly thought that an employer can pay wages a week after they're due. They actually can't, and particular termination payments and redundancy payments should be paid within 1 or 2 business days. Otherwise, there's a technical breach of the Fair Work Act, although it's not very much policed. But it's important to know that I was at a seminar recently where a barrister pointed out that probably a lot of employers are potentially in breach in paying, particularly payments for ending of employment, such as notice period pay and annual leave accruals. They might be paying late, so they might be paying it a week later, or even if the employer paid monthly, they might be even making those payments 2 or 3 weeks after the ending of the employment, and that's too late, and it's a breach of the Act. So penalties can apply, as the slide says, but I'm not aware of penalties being applied in that situation at all. So on to the next slide. So the National Employment Standards, the NES, people may have heard of it, but it is a series of 11 terms and conditions that an employer cannot go below, but not all of them relate to payment of wages. Some of them relate to um, other benefits, and I will read them out. I don't know the whole 11 off by heart, but they do include 38 hours working week, a right to request a flexible work arrangement, 12 months parental leave, 4 weeks paid annual leave, certain amount of days of sick leave per year, usually 10 or 12, carers leave of 2 days per year, compassionate leave, and the relatively new unpaid family and domestic violence leave. In addition, there's further NES elements are long service leave, paid public holidays, notice of termination and redundancy pay, and the 2 Fair Work information statements and the casual working information statement as well. So the NES, as it says, is a floor below, which is illegal to provide less. It's actually a breach of the law. It's illegal for an employer to pay less than NES and would not provide those matters in accordance with the minimums. In addition, modern awards which apply to certain industries and job titles and enterprise agreements also provide a floor below or a safety net or a set of minimum terms and conditions to employees in certain jobs which apply in addition to or on top of the NES. So modern awards can cover all terms and conditions of employment, rate of pay, levels, classifications, dispute resolution, all those types of things. So modern awards particularly and the NES are very important. The NES are basically the first principle. Then I think we've got modern awards come in secondly. Sometimes there's an enterprise agreement that applies to a certain set of employers, and provided the employment contract, which is probably the most important document in relation to underpayments or payment of monies by an employer to employee, the employment contract can never go below the NES, and the employment contract can also never go below the award. So if there is an inconsistency and one provides less than the other, then the contract will apply, but the contract can never go below what an award or an NES provides. The Australian Fair Work Act has a series of provisions spread out through the Act, which also provide legal obligations on employers as to not only how much to pay and when and how, and also the method of payment as well, and particularly the amounts. So that's the Australian Fair Work Act, which is a very comprehensive set of legislation, but deals with a lot more things besides payments of remuneration, provides many other things as well. So we can go on to the next slide. So the Fair Work Ombudsman is the educator and the regulator Australia-wide. It's a body formed by the Commonwealth Government, has a website, has a educational training and enforcement arm as well. So they are often the first point of call if an employee is not being paid correctly or being paid at all. However, they do have the limitations in that it's my anecdotal experience, what employees have told me, that they can be very slow in following up payments. It can take months to get some action. And I think the impression is that they're under-resourced compared to the amount of inquiries that they receive. And in addition, what will then happen is that they'll want to hear the side of the story of the employer, and the employer is not required to engage with the Fair Work Ombudsman. So the Fair Work Ombudsman might suggest a mediation where the parties can resolve it informally, but the employer is at liberty, if they wish, to just ignore it, not turn up to the mediation, not be interested in engaging in it. The Fair Work Ombudsman will step in, though, in certain cases where they feel it's in the public interest to do so, where there's a number of employees. I acted for a cafe many years ago where I think it was about 55 employees who were paid a flat rate across the board. They weren't paid weekends or penalty rates, public holidays, and so forth. And the Fair Work Ombudsman did actually issue proceedings in the Federal Circuit Court, which was what it was called at the time. there was 55 employees. Many of them were vulnerable. Many of them were migrants and or casual workers with English as a second language. So the Fair Work Ombudsman felt that those people were vulnerable and stepped in and actually issued proceedings themselves in their own name on behalf of those employees. The second option there is a letter of demand, which lawyers write letters of demand all the time, but there's no reason in particular if the employee who's not being paid correctly either before they leave their employment, which is obviously trickier, or after, to send a letter of demand, making the demand, setting out why they say it's payable, setting out the amount that's owed, and then also providing for what the consequence is if the payment's not made within a certain time frame, suggested around about 14 days, and then saying that if that payment's not made within a time period, that court action will ensue. As it says there, court action is always an option. However, it is a last resort because it says that there can be a costly and time-consuming and stressful exercise. I've got a matter running right now where it's probably been 18 months since we started the proceedings in relation to a fairly large payment of non-wages, non-payment of wages, and we still haven't even had a mediation yet. So that's a little bit out of the ordinary. They usually go a bit quicker than that, but the court action is a last resort. So unions can assist as well, and they do, and they have, and I'm aware of recent instances where they have done so and got good outcomes for the employees. But like anything in life, it can depend on who the union is, it can depend on who the person at the union the employee is dealing with. But certainly there are particular unions, which I won't name any names, who will really go in and bat pretty hard for the employee and get some outcomes. And almost, and the employee is obviously all they have to pay is the regular payments out of their wages, the union dues, and the union will often step in and almost act like a quasi lawyer. So it's depending on which union it is, though that does not always the case. But union is another, and also one that's not listed there is community legal centres. And legal aid only has a very residual role, if anything, in the employment law space. But community legal centres, provided you pass their means test, they can often give more advice, but they can, in some cases, initiate some actions or send some letters to follow up non-payment or underpayment of wages for employees and other entitlements, as we said. On to the next slide. So possible outcomes. So a court really has a very wide discretion as to what they can what they can order. Obviously, what the employer really wants is they want to be paid their entitlements, their current entitlements. The court can award back payment of all their entitlements all the way back to when they were owed. Now, interest can be paid or made or ordered by the court, but that's completely at the discretion of the court. They don't always. Generally, interest has to be either by an agreement, which most employment contracts won't say that if wages are late, interest is due. But interest can also be payable by legislation. Fines is a significant deterrent, I think, for a lot of employers. Obviously, with the underpayments and non-payments in the wages, fines is obviously not enough in some cases. I think there was another really large bank, I think it was the other day, who had underpaid wages to the tune of $20 million. So fines can be ordered by a court for contravention of these laws, and $495,000 per contravention, which means that if there's 50 employees, by way of example, who have been underpaid, then you've got 50 times $495,000 per contravention. And that's not to mention the back payments which be ordered and possibly interest. Now, wage theft is obviously a very live term in this space. A lot of people don't really know exactly what wage theft is. A lot of people would think that wage theft means, well, if I'm underpaid, that is theft. But as it says there can be jail time ordered for wage theft, but it's only for deliberate or reckless underpayment. So something where the employer actually knew that they were paying less than what they should have, or when I say reckless, it means that they suspected or thought that they might be paying less, but they just decided to pay what they did anyway, not really knowing or caring whether they were paying the correct rate. So that can be a bit of a burden of proof for the Fair Work Ombudsman, or whoever the prosecuting authority is, to try to actually have to prove to a court satisfaction that there was a deliberate underpayment. So it's not for mistakes. And I know that a lot of the people in the public say that these big companies should never be getting it wrong, but we do have a complex industrial relations system in Australia. I actually find it conceptually difficult sometimes to give advice on all the entitlements pursuant to one award, so it's not an easy course to travel for a lot of employers. But wage theft means that exactly, theft. There has to be that deliberate and conscious decision to pay the wages or not pay the wages which are due. Thanks, Carl. So basically, the employing entity is liable. And in other words, who is the company that's named on your payslip? That's who your employer is. Sometimes there's corporate groups where a company might be known as trading as something, but whereas the employing entity per se is a separate company altogether. And so it'll be the actual employer itself that's liable. Now, accessories. Some people know accessories and that concept from American TV shows. If you're an accessory to a crime, what this means is that if people who are in the business who had some involvement and were aware of the underpayments or the non-payments, as I say, they particularly if they actually guided and or managed, so they have some real involvement in it, not just sort of knew about it and just turned a blind eye. But if you payroll staff, HR staff, directors, senior employees, CEOs, COOs, chief financial operating officers, all those types of people, if they're aware of the facts surrounding the underpayment, in other words, that the person was paid an amount and it may or may not have been, or it was underpaid or below the minimums, then accessories can also be fined. And if they have the requisite intention to underpay, as we said before with wage theft, they can also go to jail. Don't know if anybody's gone to jail yet for these things, but time will tell. The national wage theft laws in Australia are relatively new. There was Victoria who had their own wage theft laws. They repealed them, and now it's Commonwealth Government or Australia-wide these new laws on wage theft. So they're relatively new, so it'll be interesting to see what happens in due course as to the penalties that get awarded, whether the employees will be getting those monies and whether jail sentences will apply as well. Thanks, Carl. Yeah, so that brings us to the end of the assessment. So a very topical issue in the media, and a lot of bigger companies with complex payroll systems are still getting it wrong. So it's not an easy thing to advise on, and it's not an easy thing sometimes for the employee themselves to actually know they've been underpaid. Of course, they know they've not been paid, but if they've been underpaid, it can happen for years, and all of a sudden somebody has another look at something, and it comes to the surface.
Yeah, and thank you, Paul, for that seminar. I think quite pertinent points that you've raised. Just a reminder that this session is being recorded, so if you have joined late, you can always watch the entire session online. And there's a one-page handout which Paul has kindly prepared, and I'll share that with registered participants following the closure of the session. Paul, we'll jump into Q&A now. There's a question that I want to ask you, which is around, oftentimes it's when the employer notifies employees that there's been underpayments that employees find out about this. What proactive steps can an employee take to get an independent assessment of what they're being paid? Do you have any thoughts on that?
Well, one thing is that it's not very independent, but you can go to your HR department and say, look, am I being paid correctly? That's often not a great option. There may be some small chance of some sort of pushback or fallback onto the employee for asking the question. So potentially HR people are not the ones to go to. But the Fair Work Ombudsman, which I mentioned, they have a very big role in advising employees, and even I think sometimes employers, as to what their entitlements are. So to me, that's often where I refer people away when they want to get some information as to what exactly they should be getting paid. Fair Work Ombudsman.
Mm. Because you mentioned that sometimes the award can be quite complex, and I think it usually arises. If you would agree, Paul, that you know there's a greater chance of people being underpaid when they're under awards, or they're being their work hours are not consistent. Those that are in trade operations, or
Yeah,
in the health industry, nurses. There's a higher chance there where it's so complex, their entitlements. It's often hard, I think, as you mentioned, for the employer to even get it right. And you've seen it time and time again. Sort of what steps can you recommend for the employer? If you're thinking of a small organisation or one that's even medium sized, which doesn't have probably a very strong and robust HR team or employment team, but sort of what steps do you think you can recommend for those organisations to, I guess, check what they're doing and align with what they should be doing?
yeah. Well, I mean, obviously, the vast majority of businesses in Australia will not have a HR department at all.
Yeah,
Small family businesses won't have a HR department, and it's recognised in the Fair Work Act in this slightly different jurisdiction, but in the unfair dismissal jurisdiction, it is a factor going to whether a dismissal is unfair as to whether an employer had a dedicated HR department or had access to HR resources or help. So there's a lot of HR companies around that will be able to give really good tailored advice as to those issues, what should be paid in the classifications. Unions can help, and also lawyers as well. There's a lot of employment lawyers who deal a lot in this space. And particularly, an issue that comes up a lot in that context is with an award. Well, we know which award covers me, because even that can sometimes be complex to work out which award applies, because sometimes there's two, even arguably three, that could apply. There's some awards and some I've looked at recently where there's levels, like say 8 levels, and even within each level there's about 8 classifications, and then you've got shift allowances, you've got living away from home allowances, and all these various other ones. I haven't even described all the allowances. I think there's about 40 in total. If you add all those onto it, and some awards, I think the Building and Construction Award might be one of the more complex ones, and also the SHADS Award, which is the Social and Community Housing and Disability Sector Award. That's a very common one and a complex one as well. And with all the proliferation of NDIS providers, the SHADS Award is becoming a very common one for people to be wanting advice on as well.
yeah. Paul, can you remind our viewers, just around superannuation and what they can do if they feel they're being underpaid with super, or not being paid their super?
Yeah.
Sort of, can they do anything to sort of to further that issue with their employer?
So with superannuation, some employers, unfortunately, and it is the vast majority, look on superannuation as an unnecessary expense, something that if they can avoid paying, they will. And particularly when they're having cash flow problems, superannuation for their employees seems to be one of the last things that will be getting paid. And the Australian Taxation Office has the almost sole responsibility in this area. They will follow it up, and they do go hard, but it takes time. I personally myself had an issue with an unpaid superannuation. It took a year. I'd forgotten about it. And the ATO wrote me a letter saying, "We've recovered your super. It's now in your super account." So the ATO has got a role, or mainly the only role, and they will go hard if directors of companies are not paying super over an extended period of time. They can be made personally liable. So not the company itself has to pay, but the directors themselves may have to pay, and they can be also form the basis of director penalty notices. All those types of things can actually result in companies being made insolvent just for superannuation and/or unpaid taxation.
Yeah, Paul, you actually touched on an important point, because I'm sort of jumping to another question that we received, which relates to your last point about the sort of insolvency. Well, what can employees do in an instance where these payments push an employer into that insolvency regime? are employees prioritised in any way, or do they just have to wait and see if their employer will pay out what they owed?
So first of all, the insolvency laws do provide priority to employee entitlements over unsecured creditors. Secondly, if that doesn't work, because if there's nothing in the pot, there's nothing in the pot. There is what's called the I think it's called the FEGS scheme or the GEAR scheme. FEGS, Fair Entitlements Guarantee Scheme. It's a scheme funded by the Commonwealth Government to cover payment for employees who do not get paid all their entitlements, whatever they are, due to insolvency of their employer. So you just make an application with the FEGS scheme, and if you Googled FEGS scheme, FEGS for Sam, you'll find a lot of information. There are qualifying criteria. It can't just be that, say, the company just shuts down or deregisters and just disappears. That doesn't really apply. It has to be that the company has gone out of business due to insolvency, and that's when the FEG scheme will kick in.
Okay, right. And Paul, we've got another question. I'll just qualify it by saying to that person that asked that question that any sort of financial or taxation advice should be separately sought. But Paul, this question is just more in relation to taxation obligations on the employee for receiving, they do get paid out, underpayments from prior years.
Yeah.
Does that still trigger tax obligations, just generally speaking?
Yeah, well, I'm very reluctant. I can only give something very basic because I'm not qualified to give taxation advice. It's not my area. I'm also not qualified to give taxation advice because I'm not an accountant. But I think if it's money received that's a replacement or a payment for income that was not given previously, it's taxed on income.
Yeah.
And that's the unfortunate thing in these situations is one thing I'm aware of that I can tell you through my own personal knowledge is that you get more tax on a lump sum or a bulk payment than a smaller sum. So if you do get a large back payment, of all, say 5 years, for example, of underpaid wages or non-paid wages, and you get it in one lump sum, you're going to be paying more tax than if you got those payments over time.
Yeah. I think to that individual that asked the question, probably recommending getting separate financial advice and taxation advice on what the implications are.
Yeah.
Yeah, because you'll be, I think you'll have to be required to amend prior tax returns as well. And there's a bit of a process involved, so you might have to speak to your taxation agent if you have one to work out
Yeah,
a
that's right.
approach.
Yeah.
Yeah.
I mean, there's other things I could say about that, but I'm not really 100% au fait
Yeah.
with it. So I won't really be able to say anything further. Yeah.
No, that's right, Paul. And Paul, just a question that we've got on those employees that have now left the employment of that employer that underpaid them. What options can they pursue if they're no longer an employee? Do they still have a right to claw back anything, or?
100%. In fact, it's very much easier in a sense to pursue an employer that you're no longer employed by, because imagine if you're employed and you know for certain that your employer has underpaid you. I mean, what are you going to do? Send a letter of demand to your current employer or take your current employer to court? That takes a lot of guts to do that. And I've had clients who insisted on doing it, but then they often find that they lose their employment in the end. So yeah, once you've left your employment, generally you've got about a 6-year limitation period after that, which is what's technically called after the cause of action accrues, which is those payments don't get paid at termination. You've got 6 years. Yeah, that's when you're in a better position to pursue it is when you're left rather than when you're there, because as you say, you're making a claim for payment, and there are laws in place, the general protections provision, which say that if you raise or exercise a workplace right to make a complaint or inquiry about your employment, it's unlawful to be terminated. But the reality of it is that, and I'm hoping the vast minority, when a current employee raises an issue about non-payment or underpayment with their employer, the employer can sometimes get pissed off about that and terminate the employee, even though it's unlawful adverse action, and it does give rise to a claim. So you're really in a lot better position, a lot more practically able to follow up after you've left the employer. So you've got 6 years to do it.
Yeah. Is it costly? Like just an extension of that question, Paul, to sort of pursue after the fact. Is it an easy process through Fair Work, or do you have to sort of independently sort of start proceedings? Like, what's your experience in the most efficient
Well,
pathway?
what I would always do is it can become expensive, and but going to court, these Federal Circuit Court and Family Court of Australia, that's all one court now, believe it or not, and or the Federal Court can chase these things up. Particularly the Federal Circuit Court and Family Court, they've got a small claims division, and a Fair Work division which deals with these types of things. But again, they're court, and you sometimes need a lawyer. They are informal, or a bit more informal than what other court actions might be. But the bottom line is it can still become an expensive exercise to go through court. To me, as I said, court's your last resort. Try the Fair Work Ombudsman. It's not all cases that they're not. It's not that unpaid wages are not paid through the Fair Work Ombudsman. I'm sure there are success stories, and many of them. Just what I hear is that um, it's a luck of the draw. You get a case officer who's really good and really onto it, and works quickly and works hard for the employee, and the employee gets all their money back. But then there are a couple of other cases where I've heard, for one by way of example, where the employee persisted and kept trying to get communication by the case officer, and 4 months later still had nothing, no communication. What have you done? Have you contacted the employer yet? No, we haven't yet. We're going to do it shortly, and he gave up. But that's to me, that's the worst case scenario. So you might as well try the Fair Work Ombudsman at first. You've got time, and I know that if you've got haven't been paid wages, you really need it. I would send a letter of demand at the same time. If you can
Yeah,
qualify, see a community legal centre because they're free. See if they can give you something. Every now and then they will write a letter, and a letter can sometimes do it alone. And even if you see a lawyer for unpaid wages or non-paid wages, you're talking about a relatively small fee, in the few $100s, rough general mark, to send a letter of demand, and a letter of demand can sometimes fix the problem.
yeah. No, there definitely are options available, and I think for those that are in the situation or are likely to be in the situation, it's probably best to sort of think strategically about how you'll go about recovering what's you're entitled to. And I think I think as you said, Paul, it's a growing issue. I think as it gets more complex, businesses are sort of, more, um, they're working in situations where they're potentially cost pressures and, trying to race around the clock to get things out. They're a good sort of manufacturer and all that. Then there's a real high risk that they might miss certain things, like from an operational perspective.
Yeah,
But it sort of goes towards the next question, which is around, it is hard, I think, for employers to sort of get it, right. Like when you think about having the right systems in place to ensure that people know what leave balances they've got and what they're entitled to from that perspective. Do you see that, Paul, in your experience, you've worked, or supported, or both sides really? Do you see that maybe a lacking of sophisticated resources on the employer sort of led to
yeah,
the issue sort of surfacing or really exacerbating unnecessarily? Do you see that being
yeah. Well, 100%, because you might be I'll just pick an example out of the air, a builder, and you're great at building. You got great clients, and you do all these things, and you know how to run a business, and you know how to build. But the skill set to do HR or to know about these things is a separate area altogether. And like any person, even a lawyer, because you're a good lawyer doesn't mean you're a good business person. Because you're a good builder doesn't necessarily mean you've got HR expertise, and it's not easy. And I do have it said to me by a lot of employers, who ask me relatively simple questions. And there's no silly question, but they're simple questions. And to me, it illustrates that even the most basic HR information, such as which award covers his employee, or do I have to pay him working away from home allowance when he works away from home during the week and comes home on weekends, sometimes employers have no idea. They say, oh, or that they might ring somebody and say, have a look at the award. So they bring up the award and they see it's 278 pages long, and they think, oh my God, where do I even start? So then they think, all right, I'll try and work it out. I'll go to the table of contents and we'll see where it says allowances. So let's go to allowances. And then the allowances section is 8 pages long. And the employer has now spent 2 hours on trying to answer a simple question and he's gotten nowhere. It's not easy. Not easy. And I'm not making excuses for smaller and particularly for bigger companies, but a lot of them get it wrong because they make mistakes.
I think it's just the reality, Paul. I think I agree with you. I think that some of the documentations are way too long. You really need to pay attention when you're reading them because they can have, clauses that relate to other clauses and all these other little bits and pieces and how you interpret it as well. It almost becomes a sort of a cost of doing business that you actually do have to engage a professional, like a lawyer or someone familiar in sort of employment law and,
Yeah.
and practices to then actually properly advise. But I think a lot of the times, they rely on software or tools to help them, manage these entitlements. But whether they get those, whether those software and tools get it right or not is another question. Um,
Well,
but
the other
definitely,
thing that
yeah,
employers might be trying to do now and get more tempted, and I'm hearing this a lot more with all various things, is the employer then says, let's see what ChatGPT has to say about it.
yeah,
That'll give
it's
me
not.
the answer. And then, and
Yeah,
then, and then the lazy way to do it, but the employer may have spent the last 3 hours trying to answer a question, is that they'll cut and paste the answer out of ChatGPT, send it in an email to the employee, and there's the answer. And guess what? ChatGPT has hallucinated again and given false information, wrong section numbers, and if it's ever relevant, incorrect case references that don't even exist. That's not to say that ChatGPT can't assist with these things. The thing about ChatGPT though is that it's good for people who know a fair bit about the area and are just wanting to maybe
yeah,
broaden their knowledge just a little bit more, and so that they can fact check as to what's been said. But if you don't know and you take what it says as gospel, you won't know what's fact and what's not.
that's right. And I think we've seen sort of cases in the media as well of individuals relying on it in the wrong way, and that whole risk of hallucinating responses, I think, really does throw into question. You need to check what you're reading, and you're right. You need to have a strong sort of command of what you're actually searching, so that you can reasonably interpret what you're getting at from those
Yeah, and
generative AI solutions.
this seminar is not about ChatGPT, obviously, but um, recently there was a QC in a case, and the judge rebuked him and the prosecutor. The prosecutor didn't take issue with and didn't notice that the QC had given incorrect case references for certain propositions. The cases didn't exist, and the court was
Yeah,
scathing and said it wasted the court's time. And the other
yeah.
party, the prosecutor, didn't notice that the cases didn't exist either. So both parties to the proceedings got it wrong.
Well, that's right. And in these types of scenarios, any lawyer is not the fully knowledgeable of all areas of case law and all that sort of stuff, right? So
No,
there's always going to be slip ups in that respect. But I think it just goes to show that if we can't, as legal professionals, get that right, what does it sort of really mean for employers who've got so many other things that they're thinking about on their mind?
they
As you
do.
say, and are they really skilled to even be able to apply what they are obligated to do?
A
It's
lot
sort
of
of
small business people are multitasking. They've got more than one ball in the air. Particularly, imagine, say, and I'll say this is a female who's got a family who's looking after kids, but also running a business, and she's got a complaint by one of her employees. Who this employee might have looked on ChatGPT, and ChatGPT's told her that she's being underpaid, and then just add that to the pile of stuff that the small business owner has to do, and in that case, unnecessarily. But you have to make sure, and she has to follow it up, and she has to make sure and satisfy herself that they are paying correctly, because it's important for everybody. In the cost of living crisis, employees need to be paid correctly.
well, that's right, and you also then ensure that your employees are, I guess, engaged with your business. Because if they sort of get a bit skeptical about what they're entitled to and what they're being paid, it might break that trust.
That's
So I think
right.
it's in the interest of the employer to get it right. And also, you don't want to be seen as not paying the right amount or underpaying or not paying or late paying, you're not going to really get much engagement from future employers because they might see it as a risk of being part of that business, right?
Yeah, that's right.
Been great. Thank you so much for your time today, and I hope those that have joined today and will listen in the future will take something away. It's definitely an issue that is pretty, systemic. I think, Paul, you would agree. And it's best to know what you can and can't do, and be prepared if you do face into the situation or think that you are about to face into the situation. So I'll bring Paul's details back up on screen. Principal at Law and Lydiard. So if you do have any questions for Paul or about this matter, I suggest you get in contact with him or someone that's experienced in this space. So I'll bring today's session to a close now. Just a reminder that today's session is being recorded, so you can always watch the entire session online. And Paul has prepared a one-page handout, and I'll email that to those that registered through Eventbrite. We do rely on sort of word of mouth and social media engagements. If you have found this useful, please share it with family and friends. If you think the YouTube clip will be of use to someone else, recommend that you share it with them as well. And I'm sure that Paul will be happy to take a call or an email if you do have any questions about this area, given this is this area of sort of specialization. So that brings us to now the end. Thank you, Paul, once again for your time, and to those that have joined. And
No
hope
problem.
you're blessed.
Thanks, Carl. Thanks, everybody.
Right, bye. Thank you. Bye for now.
Have a good night. Thanks.